At this juncture, it is also pertinent to note that in the most of the cases, the dowry death of deceased is caused inside the house of the accused persons, and all the relevant facts as well as incriminating evidence are only in the knowledge of the accused persons, but they do not come forward to disclose the fact happened to the deceased soon before her death. Full stop. Therefore, the prosecution cannot be blamed to produce such evidence which is not in the possession and knowledge of the prosecution witnesses. Full stop. Para. In Trimukh Maroti Kirkan versus State of Maharashtra 2006 10 SCC 681, where accused was charged for committing murder of his wife for want of dowry, and it was established by the prosecution that shortly before the offence he was seen with his wife inside his house where he and his wife were normally used to reside. Hon'ble Supreme Court has held as under para, where an accused is alleged to have committed the murder of his wife and the prosecution succeeds in leading evidence to show that shortly before the commission of crime they were seen together or the offence takes place in the dwelling home where the husband also normally reside, it has been consistently held that if the accused does not offer any explanation how the wife received injuries or offers an explanation which is found to be false, it is a strong circumstance which indicates that he is responsible for commission of the crime. Full stop. In Nika Ram versus State of Himachal Pradesh AIR 1972 SC 2077, it was observed that the fact that the accused alone was with his wife in the house when she was murdered therewith khokhri, and the fact that the relations of the accused with her were strained would, in the absence of any cogent explanation by him, point to his guilt. Full stop. In Ganeshlal versus State of Maharashtra 1992 3 SCC 106, the appellant was prosecuted for the murder of his wife which took place inside his house. Full stop. It was observed that when the death had occurred in his custody, the appellant is under an obligation to give a plausible explanation for the cause of her death in his statement under section 313 Cr.P.C. Full stop. The mere denial of the prosecution case coupled with absence of any explanation were held to be inconsistent with the innocence of the accused, but consistent with the hypothesis that the appellant is a prime accused in the commission of murder of his wife. Full stop. In the state of UP versus Dr. Ravindra Prakash Mittal AIR 1992 SC 2045, the medical evidence disclosed that the wife died of strangulation during late night hours or early morning, and her body was set on fire after sprinkling kerosene. Full stop. The defense of the husband was that wife had committed suicide by burning itself and that he was not at home at the time. Full stop. The letters written by the wife to her relatives showed that the husband ill treated her and their relations were strained, and further the evidence showed that both of them were in one room in the night. It was held that the chain of circumstances were complete, and it was the husband who committed the murder of his wife by strangulation, and accordingly this court reserved the judgment of the High Court reversed the judgment of the High Court, acquitting the accused and convicted him under section 302 IPC. Full stop. In State of Tamil Nadu versus Rajendran 1999, 8 CC 679, the wife was found dead in a hut which had caught fire. Full stop. The evidence showed that the accused and his wife were seen together in the hut at about 9 p.m. and the accused came out in the morning through the roof when the hut had caught fire. His explanation was that it was a case of accidental fire which resulted in the death of his wife and a daughter. The medical evidence showed that the wife died due to asphyxia as a result of strangulation and not on account of burn injuries.